morning. Welcome to the Labor Relations session of our conference on fostering a healthy workplace. With me are my colleagues Claudia Desjardins-Bellil from the Montreal office and Justin Deagle from the Toronto office. I'm Hugh Dyer. I'm also from the Toronto office. Our agenda, let's go to our agenda, and as I have control of the clicker, which I seized from Justin a few minutes ago, we'll look at...
Forcibly seized.
Yes, it was kind of violent, actually, but workplace violence is a terrible thing. We're going to talk about two major topics today. An update on COVID-19 vaccination policies. All of us are perhaps getting a bit weary of COVID vaccination policies, but nonetheless, there has been a lot of case law on it, especially in the last few months. So we're going to touch on some of that. I'm going to address that from the Ontario perspective primarily, and Claudia is going to jump in with some comments from the Quebec perspective. And then Justin's going to talk about, Claudia and I are going to talk about the reasonableness of a vaccine policy and the enforcement of the policy. And Justin is going to deal with religious accommodation, which has become a big issue in the enforcement of vaccination policies, as you probably all know. But I think Justin's also going to take it a little bit further, because now that we've had the case law that develop on and continue to develop on religious accommodation as a result of the vaccine mandate cases, we expect that it may keep coming up. And then we're going to give you some practical advice on policies and where we go from here. Then Claudia and Justin, led by Claudia, are going to talk about an update on paid sick leave entitlements. We're going to talk about some statutory stuff, although Claudia tells me she's going to zip through all the boring details in the slides about the statutory provisions. And then we're going to talk about the intersection of the statutory requirements, the new ones, and the ones that are on the immediate horizon. That would be the federal one, which comes into effect on December 1.
December 1st, yeah.
And the intersection of those with collective agreements. Okay. Normally we save the questions to the end, but if you do have questions that come to mind during, given a relatively small group, if you have questions that come to mind during the presentation, just get our attention and we'll try and answer them. Okay? So, starting with our update on COVID vaccination policies. Oops, did I go too far? No, I didn't. So, I think everybody probably knows the background of this, but very briefly, in the middle of 2021, as the Delta variant was starting to spread rapidly and was of great concern, and as the vaccines were becoming more readily available and so on, many employers in both the public and private sector began to consider introducing vaccine mandates. In other words, the requirement to be vaccinated with at least 2 doses of the approved vaccines. Some sectors, in particular in the public sector, hospitals and long-term care, and, school boards and so on, were required by a government directive to have policies like that. The content of those policies differed somewhat, but in some cases they allowed employees to use testing, remain unvaccinated for at least a period of time, and do rapid antigen testing as an alternative. That stayed in effect for a while. Some of those policies were later modified to require vaccination in all cases. In the private sector, and in the public sector too, there was a considerable recognition that there was a health and safety obligation imposed by law, and that it was a good health and safety practice to require employees to be vaccinated. Now, like any other unilaterally introduced policy, these policies were subject to review at arbitration. Many trade unions, even though they did somewhat reluctantly in some cases, challenged the policies on the basis that they were inconsistent with the collective agreement or unreasonable or didn't otherwise comply with the rules that have to be met with respect to any unilaterally made employer policy. Often the unions did that because they were under pressure from people that were reluctant to be vaccinated. Union reps will tell you they don't necessarily agree with that, but they were doing their duty by their members as they perceived it. In any case where there's a unilateral policy introduced by management of any kind, the KVP test is the foundation that has to be considered. KVP was an arbitration decision from, I think, 1967. Interestingly, if you go back and look at it, it's kind of an interesting artifact. It deals with a case where an employee was fired for having too many wage garnishments. And how much were the garnishments for? $7, $21, $42, and I think it was the $7 one that got him fired. So anyway, in that context of that sort of archaic set of facts, the arbitrator developed a 6-point test, which has been used ever since, been approved by the Supreme Court of Canada as an appropriate test in assessing unilaterally made employer policies. And the 6 elements of it are that a policy must be consistent with a collective agreement, it must be reasonable, it must be clear and unequivocal, it must be communicated clearly to the employees before it's enforced. If you're going to discharge an employee as a result of a violation of the policy, you have to warn the employees to that effect. And lastly, it has to be consistently enforced. Now, the majority of cases turn on whether or not an arbitrator believes the policy to be reasonable. And what do they assess in determining whether or not a policy is reasonable? They balance the interests of the employer versus the interests of the employees. In the vaccine mandate cases, the competing interests are basically, from the employer perspective, protecting health and safety of the workers, and in cases where the workers are taking care of other human beings, protecting the health of other members of the public. The competing interest, from the employee perspective, is integrity of the person, privacy rights, and just the belief, I guess, not religious for the moment, that vaccination isn't a safe thing to do. And the primary purpose that employers are addressing, as I said, other than the protection of clients or patients or whoever, students, is the health and safety perspective, and that has a statutory foundation, both provincially and federally. Provincially, the standard in the Occupational Health and Safety Act is that employers have to take every reasonable precaution for the protection of health and safety. The federal sector is even a little bit more dictatorial. It says that employers must ensure the health and safety of workers. So pretty strong language. So what have arbitrators considered in assessing the reasonableness of vaccination policies? Essentially, they look at it from what they call a contextual perspective. The contextual perspective is both what's the environment like at the employer's facility or facilities and in the surrounding communities. And excuse me, the context is also generally assessed from a temporal perspective when the policy was introduced. So most policies were introduced in the later half of 2021. Delta was emerging. Delta was worse than the previous variant. Delta was seen as being subject, there was pretty good protection from transmissibility from the vaccines and so on. So that all was part of the context. Also things like public health guidelines and, what the local public health organization said was a good idea, that was taken into account. Obviously in the sectors where there were mandatory directives from government about vaccination and so on, for the most part, that solves the reasonableness issue. If the government directed, for example, a hospital, or all hospitals, as it did in this province, to have a vaccination policy, the arbitrators have generally said, in fact, I think all have said, well, the policy is reasonable. We don't have to go any further. Now, whether or not there could have been a charter challenge to the Chief Medical Officer of Health's directive on that point, conceivable, but it hasn't emerged, and I think it's unlikely to emerge at this point in time. So, other considerations, what's the severity of the pandemic? Not just worldwide, nationwide, province-wide, but community-wide, and in the plant in particular. For example, there have been workplace outbreaks in the plant. Obviously, if there has been, that's a significant indicator that a vaccination mandate may be a reasonable thing. I don't think you have to have an outbreak to prove that it's reasonable. Arbitrators have said that, you know, in taking every reasonable precaution, you don't necessarily have to have had a serious COVID problem in the workplace, but obviously, if there has been, that's an indication that supports the policy. And then we come to what I think is the key test in most cases, which is the nature of the workplace. If the workers are, as we used to say during the pandemic, essential, in other words, they must come to the workplace every day or most days, then that is certainly, and also if social distancing isn't possible in all circumstances, that was seen as being an important factor in supporting a vaccine mandate because the vaccine was a barrier to transmission, especially with Delta. As Omicron became the dominant variant, and the variants of Omicron became dominant, the vaccines were less effective against transmissibility, but there was still, the evidence suggested, significant benefit in terms of reducing severity of illness. And that's obviously the efficacy of the vaccine point. And the last one is, and this is the counterbalancing factor, are there other alternative means which are less intrusive but are effective? The short answer to this in all of the arbitration cases that I've read is that unions generally trying to attack the reasonableness of a vaccine mandate said, well, there are other measures that the employer can take that limit transmissibility and so on. For example, masking, physical distancing, physical barriers, and most commonly, rapid antigen testing on a regular basis. And arbitrators have said, well, those things are helpful, but they're not the most effective means of preventing transmission. Vaccines are the most effective means of it, even if there is a somewhat diminished efficacy of the vaccines given the emergence of Omicron. Now, like in law school, we're going to look at sort of the outlying cases. Lawyers always talk after law school about, you never learned on any of the central cases. We learned about things on the fringe that sort of teach you about the law, hopefully. So I'm going to talk some of the cases that are a little bit on the extreme. As I said, and alluded to already, most arbitrators have found in most cases where workers have to come to the facility and there can't be social distancing and so on, that a vaccine mandate is reasonable. And they continue to find them reasonable, even to the most recent cases, the most recent of which I think was September.
Yep.
Yeah. This case is a bit of an exception. FCA Canada is the corporation which incorporated the merger between Fiat and Chrysler. And the case involved the assembly plants that were formerly operated by Chrysler in Windsor and Brampton, I believe. And the employees had to show up. The employees had to work in close physical proximity. So all of that test was satisfied. There had been some outbreaks in the plant. There certainly was a serious problem, especially in Brampton, in the community. So all of that part of the test was satisfied. The arbitrator found that the policy was reasonable when introduced and remained reasonable until June of 2022. She then looked at the scientific evidence presented by the parties, both the company and the union, and made her own assessment of the efficacy of the vaccine as it stood in June of 2022. And she decided, the vaccines really aren't that effective anymore, and I don't think the vaccine mandate is reasonable anymore. People shouldn't be excluded from the workplace because of it. Well, the arbitrator in that case is a experienced arbitrator and so on, but she's not an epidemiologist. She's not a microbiologist. She's not an MD. And her assessment, frankly, she based it on the evidence that she had before her, as there was no expert evidence provided by either party. has been brought into question later. In the next case, which is the Coca-Cola Bottling Limited case, there have been, I think, 3, maybe 4 Coca-Cola cases from various parts of the country. Again, Coca-Cola Bottling is a facility, an essential facility. Workers had to report to the plant. Physical distancing wasn't always possible. There were outbreaks in the plant. There were serious community issues in the community. So those criteria about the situation with COVID were all satisfied. The arbitrator in this case heard expert evidence. The expert evidence was to the effect that vaccines were effective in diminishing transmissibility and diminishing severity, both when the policy was introduced in late 2021 and that it continued, although the effect on transmissibility was somewhat diminished. So unlike the arbitrator in our FCA, the arbitrator in Coca-Cola Bottling had expert evidence. And the arbitrator found that the policy continued to be valid. And he commented on the scientific evidence that was presented to him and the effect of that on the FCA case, and basically says, I still think that there is a significant benefit to a vaccination policy. And he specifically alluded to the fact that the expert evidence in that case was to the effect that no other workplace intervention provides as effective protection against COVID as does being vaccinated. So in both the federal and the provincial sector, the vast majority of wards have supported mandatory vaccination. They supported it when it was introduced. They continue to support it. Now, the only exception is that if the workers are working remotely, there have been some arbitrators that said it's not reasonable to apply it to workers who are working remotely, and in some cases if they're working outside, but those are the only exceptions that seem to have been upheld. Okay. The biggest controversy that we have now, which is somewhat surprising to me, frankly, is how do you enforce a vaccine mandate? I would say it's surprising because, I've been doing labor relations for a little while, and it's not the first time we've had policies that had to be enforced. Think of smoking policies, for example. How do we enforce those? We enforce those with progressive discipline. Think of safety policies. You have a raft of safety policies. Some, we enforce those with progressive discipline. Sometimes for really severe violations of safety policy, you get fired for the first time and an arbitrator is likely going to uphold it. But when it came to vaccine mandates, first of all, there was some diversity of what employers did. Some employers put the employees on unpaid leave, except in sectors where there was an influenza vaccination policy which had created some spin-offs. That vaccination policy, there were some cases some years ago about the implementation of vaccine policies and so on, and there were questions about it. And unpaid leaves were sort of recognized with respect to vaccination policies with respect to influenza. A lot of that was negotiated with the trade unions, though. In the vast majority of employment workplaces, unpaid leave was a bit of a novel concept. You generally enforced your policy with discipline. But anyway, nonetheless, some employers believed that unpaid leave was the proper approach. Other employers believed that discipline and discharge, the more traditional approach, was appropriate, and others combined the two. And I think, having looked at the cases and what I know from our own clients, that the merged unpaid leave followed potentially by discipline and discharge was perhaps the most common enforcement mechanism. And the unpaid leave was seen as an opportunity for the vaccine reluctant. One last opportunity to, we have this vaccine mandate. It's for the protection of your health, the protection of your coworkers, the protection of your clients, your patients, whatever, people that you work with. And if you're not going to do it, okay, you're not going to be in the workplace anymore because that's unsafe in our view. And we're going to put you on unpaid leave, and we're going to give you time to actually, rethink this and go and get the vaccine. And if you don't do it, then we're going to sever your employment, or may sever your employment.
Hugh, if I can just, I don't want to interrupt, but the reason also for that I've heard is that when these first started rolling out these policies, it's like everything with COVID, right? Oh, well, it's only gonna be a couple weeks. It's fine. We don't want to fire people if they can just go out on an unpaid leave for a little while. Just put them out on the unpaid leave, and then when this all blows over, no, I don't want to have to go through all this firing. Well, then it didn't all blow over.
Yeah.
And then the government started changing, and they started, with their directives for health care and other regard unpaid leave. Well, God, this is lasting longer. I thought, okay, well, we can't do that. Well, let's have termination. And so I think a lot of employers were playing catch up with what governments were saying, and also the fact that the thing just dragged a lot longer than they wanted to. So that kind of mucked everything up from an enforcement perspective, don't you think?
Yeah, I think that's I think the people that got into the vaccine mandates early on, especially with the policies and the enforcement mechanism, you're right. And I think they also thought, to a large degree, well, come on now. People are, 90% or 85% or 90% of the eligible population's vaccinated, so there's just a few. These people will probably get on side. But it didn't work out that way, as we know. The internet is a wonderful thing and a horrible thing. And it really, we have seen during the internet the impact, during the pandemic, the impact of what people learned on the internet is sacrosanct. It's solid. You can confront them with the opinions of respected experts and from their governments and from people that religious leaders, and they can say, I thought about that, but that really, I'd rather, to use something that's facetious, I'd rather go with this person on the internet. I don't know what his credibility or her credibility is, I don't know what their training is, but that's what I want to believe. Anyway, I'm getting on about sort of a bit of a sermon now, I'll stop.
They're just doing their research, Hugh.
I know, there was research.
Fundamental right.
It's very persuasive. Very persuasive. Anyway, the case law about the enforcement mechanisms. In one case, BC Hydro said, unpaid leave achieves the health and safety goal, shouldn't discipline anybody, shouldn't fire them. And I've read that case, and I think it's not very compelling, because the arbitrator said, yes, health and safety is the primary reason why vaccine mandates were introduced. But there are other issues that need to be considered. For example, and a very common problem is if we have to put people on unpaid leave for an extended period of time, apparently, how are you going to replace them? What is the cost of replacing them? What is the effect of that on the replacements? And all because, here I get back up on the podium a little bit, all because somebody won't do the right thing and get vaccinated. So, anyway, I think that there are other factors, and also there has been a modicum of acceptance of this principle. What about the long-term relationship with the employees that refuse to do that which they ought to do? Do you want to have that employee in your workplace? Do you want to have that employee back in your workplace? God forbid there should be another pandemic, but are we going to have to put them back on unpaid leave again if we do have one? Or are they going to say, well, gee, I got through the pandemic and the vaccine mandate, maybe I can test my next employer's policy on health and safety? The other issue which has come up, and which is one of the major issues in terms of how we actually enforce, is that some employers, when they said, discipline and discharge is a potential consequence, were a little bit more assertive and said, some said maybe subject to discharge, discipline up to and including discharge, which is sort of the traditional formulation, and some tried to be clearer and say, if you don't get vaccinated after the unpaid leave, you will be subject to discipline and discharge. And sometimes it was just discharge. And we're talking about unionized employees, and of course, and some arbitrators in particular
in this case, the City of Toronto fire case, said there the city had a very clear policy. We're telling you to get vaccinated. If you don't get vaccinated by a certain date, you're on unpaid leave. If you're not vaccinated by this date, after some period of unpaid leave, you're fired. And some of the firefighters didn't do it. And I think there were quite a large number of terminations. And the arbitrator upheld the vaccine mandate, said, yes, the city had the right, for all the reasons that we've talked about, to require employees to be vaccinated. But then he looked at the enforcement mechanism and he said, the policy is, if you don't do it, you will be fired. And he said, that is unreasonable. It's unreasonable because he said, to say to people that you will be fired is unduly coercive. And I step back and say, progressive discipline inherently is coercive. If you don't do this, you will be subject to the following: verbal warning, written warning, suspension, termination. That is a threat to do something negative to the employee if they don't behave in the way in which you want them to behave. It's inherently coercive. So to say that this was unduly coercive is to, in my view, attack the whole concept of progressive discipline. But anyway, the other part of it is, he said, it's really the employer undermining the just cause provision, saying, they're saying that this automatic termination is automatically just cause. Well, yes, that is the employer saying that that is their opinion, that this is just cause. But we all know that unionized employees, at least the vast majority of them, would have the right to grieve and go to arbitration and try and convince an arbitrator that they ought not to have been fired. There is a provision in the Labor Relations Act, which many of you are probably familiar, that allows a union and an employer to agree to negotiate a specific penalty clause into a collective agreement, and that says, for this behavior, the penalty is this. And that, he said, well, the employer, the city, tried to effectively do that here. Well, no, they didn't. They just told the employees what they were entitled to do. Anyway, I've blathered on long enough. Now I'll let you listen to Claudia from the Quebec perspective with some more interesting information.
Thanks, Hugh. Very interesting points you raised. So in Quebec, we have a similar approach, but as some of you may know, we also have protections of individual rights in Quebec that are protected under the Charter of Human Rights and Freedom, which is a quasi-constitutional piece of legislation that applies to private parties as well. So when we're looking at whether or not mandatory vaccination policies, and what Hugh discussed applies to COVID, of course, but it may also apply to other pandemics that we may see in the future, and we may need to address those and evolve with what occurs with time. So we do look at it from a similar perspective, but as I said, we have the Charter of Human Rights and Freedom. In Quebec, employers have a positive obligation, just as in other jurisdictions, to protect the health and safety of their employees, that's for sure. The tribunals have also decided that protection of the health and safety also includes taking precautions. So it's not just a question of addressing situations when there's a danger or addressing a situation when there's a risk. It's also, it also takes into consideration any kind of precaution that we may need to take to avoid a certain situation. So bearing that in mind, we have that obligation for employers, but we also have a fundamental right that belongs to individual to have a workplace that is safe. So that's one individual right that we need to take into consideration. And in parallel to that, we also have rights to privacy, rights to safety of integrity, similar things that you have in other jurisdictions. So it's not easy for arbitrators to take a stance on these mandatory vaccination policy because they really need to balance out everyone's fundamental rights, quasi-constitutional rights that we have protected in that piece of legislation and decide what is in the best interest. So we had a few decisions rendered in Quebec that all go in the same direction that what you just mentioned and what the decisions you just covered, Hugh. But one of the decisions that is still of interest to me is the Union des employés de services, section locale 800 et les services ménagers rois. Don't worry, that's the only piece of French I'm going to use during during the conference. So this was actually the first decision rendered in Quebec on mandatory vaccination policy. And the reason why I wanted to talk about this one today is I found it was fairly interesting because it was somewhat unusual, and the approach that was taken and the assessment that needed to be done was a bit different than all of the other decisions that that Hugh just discussed. So as I said, it was the first decision on this particular subject, and it was actually a declaratory grievance that was filed by the union. So the union and actually it was filed by the parties, but they wanted to know whether or not the mandatory vaccination policy could be enforceable. So they asked the arbitrator, Denis Nadeau, to take a stance and assess this policy as to whether or not it was reasonable. And so the facts were also very interesting because it was not the policy of the employer that was at stake here. It was the policies of the employer's clients. So Service Ménager Roy was a service provider for third parties, and these third parties had, in some instances, mandatory vaccination policy. Service Ménager Roy did not necessarily include those policies in their own or as their own. But the arbitrator decided that it needed to be assessed and analyzed as if it was the employer's own policy. So that question was put aside in this particular case. And then the arbitrator needed to assess whether or not those third-party policies were reasonable. And the question that was at stake here was whether or not employees could be compelled to disclose their vaccination status because they needed to be dispatched at different clients' premises. And so the employer needed to know, can I force them to disclose the vaccination status before anything else? And then can I do anything to discipline them or put them on leave or anything of that sort if my clients are asking me to send employees that are vaccinated only? And so the arbitrator decided that the mandatory vaccination policy and the obligation to disclose your vaccination status was a violation of your individual privacy rights to keep that information to yourself, but decided that it was justified as per Article 9.1 of our charter because it was in the interest of public order and in the interest of the balance of the other employees and the client's employees as well. So he said that it was justified. He balanced out everything. But at the end of the day, it's a really good decision for employers because it opened the door to forcing your employees to disclose some of their vaccination status moving forward into the pandemic. But the arbitrator did make a comment, though. He didn't go as far as allowing discipline, and he didn't go as far as allowing unpaid leave. What the arbitrator imposed onto the employer was to assess on a case-by-case basis whether or not these employees could be placed somewhere else, because there were some employers that had those mandatory vaccination policies, but others didn't. So this raised the question in the legal community: to what extent do I have to do that assessment when I don't necessarily have third-party clients that don't have that mandatory vaccination policy? So let's say you're an employer and you're not servicing third parties. Do I have to assess any position available in my workplace to see if someone can work remotely, for example, or can work in a department where the risk of transmission is lower? So that was a question that was raised in the legal community in Quebec following that decision, but it was never decided afterwards. But employers are really reluctant to terminating in Quebec, and we have very stringent rules also when it comes to termination. But one of the tips that I'm giving to my clients and counsel that I'm giving to my clients is, even if it may not be possible at the end of the day or it may be possible, to justify why you're putting someone on unpaid leave, do the exercise of assessing whether or not there are other positions that could be fulfilled by this employee for the time that he's or she's not vaccinated, because afterwards that kind of evidence will help you if ever there's a grievance that is being filed. even if it's not mandatory, it will always play in your favor to demonstrate that you did that exercise of assessing your workplace, and is there another position that I can provide to this employee on a temporary basis or not. And this has worked well for my clients in practice, and we've avoided grievances using that kind of approach. It's not mandatory necessarily, but practically speaking, it's been something that we've considered. And you need to also keep in mind that the context is extremely important. It will be difficult for an arbitrator, in my opinion, to uphold a termination of employment or an unpaid leave if remote work is available for the employee and there's not necessarily undue hardship on the employer. So you need to assess everything. Outbreaks, are there any outbreaks? Is my workplace really at risk? Is teleworking a possibility? Are there any potential accommodations? And that will really help you, practically speaking, because there's the law and then there's what happens in practice to support those decisions that you're taking. So another practical advice that I've been giving my clients following that specific decision, to avoid any debate on whether or not it's one of your policies as an employer. And I think there was a case actually in Ontario, the Compass decision, where this was taken into consideration. But to avoid all of that argument, just make sure that you communicate to your employees that you have clients that do have those mandatory vaccination policies, so that you're able to evidence afterward that you've made it your own in certain ways. So I don't know if you have any, you turn to me, Justin, and I know you always have great ideas.
I don't know what you've heard. But anyway, actually, I'll pay her for saying that later. I was just going to say, the only thing, I'm nodding my head because even though this is out of the Quebec context, I mean, these are a lot of very general principles that we would be using. I see Veronica's here from BC, others are here from Ontario. They're very good direction, practical suggestions. Thank you.
I agree, and I think that it is the remote workers or where remote work is feasible that create the greatest problem, I think, the greatest challenge if you want to enforce a vaccine mandate and impose unpaid leave or discipline. Okay, thank you, Claudia. Brief note on boosters. There are a few cases, at least one in the private sector that I can think of, and two or three in the public sector, primarily in long-term care, that deal with whether or not employers can require boosters. The cases say, subject to the same factors that we talked about, but in introducing the initial policy and maintaining the initial policy, that is feasible and may be found to be reasonable. Interestingly, in the FCA case that we talked about a few minutes ago, the arbitrator said, well, the employer's only requiring the two, the minimum two vaccinations, and those aren't terribly effective anymore. And it suggests, it doesn't clearly say this, but she suggests that if FCA had said, well, you got to go get boosted, which it would have been a more effective barrier to transmissibility, she might have found it to be reasonable. So, an interesting note on FCA. Takeaways, I think we've covered all of this. The reasonableness of a policy, including a mandatory vaccination policy, will depend on the circumstances of each individual employer. For example, the remote work situation will always be a bit of a challenge. If your workers are working remotely or working outdoors, that may be a bit of a challenge. You have to be able to show that the policy is and remains necessary, that less onerous policy wouldn't be adequate, although basically that comes down to one thing. Is the vaccination still an effective means of controlling transmissibility, ideally, and severity? And the consequences for compliance should be clearly set out. Now, if I talked about the automatic termination case, the City of Toronto fire case, the arbitrator in that case said, well, I might have found differently about this if the policy said that you will be subject to unpaid leave and may be subject to discipline and discharge. He said that might have been permissible because it's a rambling decision. And I think essentially what he was trying to get at, I don't agree with him, but he's the arbitrator, so this is what he got to make the decision. I think essentially what it's saying is, the employer should have made an individual decision about whether or not to terminate a vaccine refuser, looking at the traditional factors like service or seniority, disciplinary record, any mitigating factors, and decided on a case-by-case basis. And, all right, I can see that's what we normally do. But on the other hand, if the employer wants to terminate, exercise its management right to terminate, and take its chances in arbitration, that I think is a management right. Whether or not I'm right, I don't know.
Well, the other thing is that when you think about it, like, that's fine, that is our law, seniority, how is that relevant? I mean, like, I understand it is relevant and that is the analysis, but at the end of the day, it's either you get vaccinated or you not get vaccinated. It shouldn't have anything to do with, progressive discipline for other things, how long you've been here. At the end of the day, it's not like, you were late a couple of times and we probably should tell you not to do that. And then, you've just been late 5 minutes, you've been here 20 years. That's not this case. This case is like, this is a health and safety measure. You don't want to do it. I don't even see the relevance of that particular line of thinking, but we haven't got a lot of I don't think we've actually had, I think there's only been like one case that have actually dealt with individual ones, and didn't get into that. But anyway.
Yes, there is one, you're right. Thank you for mentioning that, Justin, because there is one in BC which was an individual termination for refusal to take a vaccination, or vaccinations, but it's slightly different because it was the employee was terminated because she refused to comply with the government directive in BC, and it wasn't an employer policy.
Yeah.
So it was slightly, and to the best of my knowledge, and I checked with colleagues this morning, none of us are aware of a case yet, there will be, a case yet where an employee was fired for violation of an employer policy, and that case went all the way through the arbitration process. And so they're coming, but they're not there yet. And oh yes, if you're going to do one of these cases, and I'm sure you're all clamoring to do one, make sure that you have appropriate expert evidence, because that was the problem with FCA. Some of you may be thinking about changing your vaccination policies. Policies of all kinds should be reviewed periodically. It may be time to review them now, but who knows? Who knows where COVID goes?
I think there was a question.
Oh, I'm sorry.
That's fine.
Just a quick one, because with something like this and with termination going, and I was just at the last session where there's the whole debate about cause and whatever else, have you seen a trend, because it happened in the arbitration that I was in, where then opposing counsel on the other side is then saying, well, it doesn't necessarily hit the measure for cause, but if you really wanted to terminate the person, why didn't you give them at least their ESA requirements? So like, why didn't you just like pay them out? Are we seeing this as a trend? And you're either like, wow, no.
Well, I mean, in settlement discussions, absolutely, right? Like that,
Yes.
You shouldn't have, but we'll give you a bit of money and give us the ESA and away we'll go. But you can't really take that position as a unionized employer unless you're arguing that the contract has become frustrated due to a health issue. And I don't know that that would be the appropriate analysis in this instance. So I suspect it's probably more of a settlement position, right? Well, if you just give them something, we'll go away.
Drop some seeds there.
Could,
Yeah.
it
Unless
could
your
come-
collective agreement has that provision, but generally they don't.
Yeah, and it could come up if the union asserts that, the employer asserts cause, says the employee shouldn't come back. But, Mr. or Ms. Arbitrator, if you find there wasn't sufficient cause, but the employee should not be reinstated, you can give damages in lieu of reinstatement. That's a remedial relief.
Right.
That's where it could come
Lake
up.
Cup's not Lakehead.
Yeah.
Yeah.
Yeah, so that's where it could come up. And actually, on that case law, if you get away with ESA, you're doing okay.
You're doing real well, yeah.
Because that is expensive stuff. It's a month to a month and a half per year of service on the basic test, and if you get into what Jason referred to as the Lakehead test, it's God knows what. Anyway, anything, so I'm sorry I missed your question. You can modify or suspend your policy, but you should reserve the right to make it and reintroduce it, because God knows where COVID goes. And finally, the vaccination requirements for new hires are probably, if you're going to or potentially have to have
a vaccine mandate in the future, it's probably best to require it at the point of hiring.
And as a point of best practice, just to finish on that point, I've been using the union's duty to represent their members as a tool in the context of the pandemic. And I don't know if you've done that, but putting pressure on the union to work with you in the application of those mandatory vaccination policy, because in Quebec, anyways, they have that duty to fair representation to their members, under the labor code, and they have to protect the interests of individuals that may file grievances about those mandatory vaccination policies, but they also have the duty to represent the balance of the members who have a right to be working in a secure environment. So you're putting them in the corner, if I could say it like that, and they have no choice but to cooperate with you in the application of those mandatory vaccination policy. And that, for some of my clients, it worked pretty well in avoiding grievances on that matter, because you always remind them of their duty to other members, and they're not too keen on filing grievances often.
Interesting point. I haven't actually tried to put the union's feet to the fire on that perspective, because the feedback they would get is, yes, we have a duty to represent all of the members, and these members don't want to be vaccinated. We're in favor of vaccination. We support vaccination, but you shouldn't do this to this person because they won't be vaccinated.
You actually see that in a lot of the cases, because you'll get some unions that'll say, okay, well, I'm not going to argue that the policy is unreasonable. We'll give you that one. It's reasonable, but it's all how it was applied to that individual member. So that's transmitting something too when you see that. Anyway, we're on to me now?
Yeah.
I think we got one more slide.
Oh, okay.
Nope.
We got a
That's
title
you.
slide.
That's you.
That's me. Okay. Oh, we're back.
You're.
You want me to take the clicker
Yes.
now? Give me back the clicker. Brilliant. Okay, we're going to, let me get back to that one first. So I'm going to switch a little bit here. It's still in the context of vaccination policies. But what I'm trying to focus on in this is, again, folks, we didn't do a canvas of the audience, but some may still have vaccination policies, some may have paused them, some may have never had them. So what we're trying to draw out here in these discussions are actually principles that are applicable to everyone. And in particular, this topic, dealing with the religious accommodation aspect of a COVID-19 policy. I'll spend a bit of time actually talking about some principles that are applicable whenever the issue of religious accommodation arises in your workplace, so you have a good sense of how to handle those cases should they come up, okay? So the first slide. General principles. Mercifully, I'm not going to read those for you, but I do want to actually find out, because before we go into it, how many people, if you don't mind, just a show of hands, are from public sector employers, broader public sector employers here? Okay, so about half and half, it looks like. Okay, so what I'm going to be focusing my remarks on, for the purposes of this discussion, are the human rights elements that are codified in statutes, particularly in Ontario, but also obviously in Quebec and elsewhere. If you're a public sector employer, there's also the question of the charter, okay? And the charter has similar protections to what's in the human rights legislation in the various jurisdictions. And some of the principles that I'll be talking about are actually principles that were derived from charter case law and might also have some application to that. But I won't be focusing on the charter so much, but I think you can do some takeaways. So here are the general principles. When it comes to this area, obviously employees have the right to object to policies or practices that they say discriminate against them on the basis of protected ground. Some general principles as well that have been noted by arbitrators and human rights commissions. You should have a mechanism in your policies to address human rights considerations. Obviously, the notion of reasonable accommodation, the duty to accommodate, undue hardship, all of that are themes and concepts that will apply in the normal course in these cases. The extent of the duty to accommodate is impacted, and this is very important for this area of the law, health and safety considerations, and we'll talk about that a little bit. And considering alternative forms of accommodation is important. Now, when you step back from what I just said, a lot of those themes are actually what Hugh just mentioned when he was talking about the reasonableness of establishing the reasonableness of a policy. So a lot of the same themes will arise here. So in terms of the analyses that you will have to engage in, move this a little forward. Everybody hear me? If I sit back here, am I still audible? Maybe I'm a little less audible, which might be better for everybody, okay? All right, so, yeah, he was gonna say so, but he said, sit back, please. Okay, that's fine. So a couple of things, a violation does not need to be intentional. You need to keep that in mind. We don't have to have an intention to discriminate. We just have to look at the effect of a policy and whether it's discriminatory in its impact. Essentially, it's a two-part test for the most part. Do you have well, it's three, I guess, broken into three. Was there a characteristic? Did the employee have a characteristic that's protected under the code? In this instance, we'd be talking about religion or creed. I'll come to that in a second. Did the employee experience an adverse impact because of the policy that we're dealing with? And was the adverse impact, was the prohibited ground that we're talking about a factor in that adverse impact? That's the legal jargon, that's the test, but it's generally those are the things you're gonna need to think about. When establishing the reasonableness, you're going to be talking about the concept of undue hardship. And that's an important concept in this sense. It's undue hardship, okay? By definition and necessity, that means that some hardship is required. That's the point. The Supreme Court of Canada has reminded that it's undue hardship. So you're expected to have some hardship. It's just if it becomes undue. This is what keeps us in business, whether it's undue, right? So that's something to keep in mind. There's a test that you follow in this regard. Essentially, is there a rational connection between the employer's policy and the purpose it's trying to achieve, i.e. vaccination, the purpose is achieving health and safety in the workplace? Was the policy developed in an honest and good faith belief that it was necessary? These two ones that I've just talked about are generally quite easy to satisfy. And then the question is, well, was that policy reasonably necessary? This is where you get into the concept of accommodation, okay? General principles. Let's move on. So when we talk about this area of the law, there are two terms that will come up depending on where you are. And the three jurisdictions we're sort of talking about on this panel are federal, Ontario, and Quebec. Federal uses the word religion, Ontario uses the word creed, and Quebec, they use the word religion. Okay. So, what's creed? The code does not, helpfully, the code does not define creed. And so the Human Rights Commission has given some guidance on what creed means. First of all, religion is a creed. But creed is not necessarily just a religion, okay? From the Human Rights Commission, creed may also include non-religious belief systems that, like religion, substantially influence a person's identity, worldview, and way of life. Okay? So that could be a lot of things. And then it goes on to say a creed is sincerely, freely, and deeply held, intricately linked to a person's identity, self-definition, and fulfillment. A lot of words here. Is particular and comprehensive, overarching system of belief that governs one's conduct, addresses ultimate questions of human existence. Like, it just goes on, right? So I'm not going to bore you with the rest of this, but there's a lot of things that can go into this concept of creed. And as a matter of fact, and not to diminish them, there have been a lot of various arguments made. The concept of ethical veganism was raised as potentially being a creed. The Human Rights Commission, when they heard about that, they backtracked very quickly and released a statement about that, saying that that isn't necessarily the case. There's something called pastafarianism that we were talking about earlier, where people have suggested that a practice called pastafarianism might satisfy. Has anybody heard of this? Oh, a few people have, my friends at the LCBO, yeah. It's essentially this concept of individuals believe that there's this entity that has to do with pasta, and you have to wear a colander on your head at all times to be observant with this creed. It has not gone very far, but in any event, you will get things like this from time to time, but what we will be talking about is not those things. We will be talking about religion for the purposes of this discussion, okay? So, Creed and religious accommodation, where do we start? Mercifully, I'm not going to butcher the language of Molière. My friend is much better with Quebec and from Quebec and in French. Syndicat North Crest, that's about as far as I go en français, and Amsalem. This is the seminal decision about religious accommodation and, by definition, religion in Creed. This was a Supreme Court Canada decision. This was a constitutional decision. And the facts were essentially, it's all laid out there for you, but in relevant part and in summary form. There were some Orthodox Jewish individuals that lived and owned a condominium. And what they did was they asked for permission from the condominium corporation to erect a sukkah. Now, a sukkah is, and I may be pronouncing that incorrectly, and my apologies if I am, but what I understand a sukkah to be is a temporary dwelling made of wood or canvas that you erect outside, and you are to dwell in that structure for a period of time in observance of the religious festival called Sukkot. And so the corporation, the condominium corporation, refused, taking the position that erecting such a structure on the balconies of the condominium would be contrary to the bylaws that prohibited alterations or constructions on the balconies. So the condominium corporation took the position that Mr. Amsalem and other individuals that were Orthodox practitioners and followers of Orthodox Judaism in the case, they could erect a communal sukkah in the gardens of the building, and they offered that. Mr. Amsalem and the others indicated that no, this would be contrary to their religious beliefs, and they proceeded to erect a sukkah in any event, and the corporation sought a permanent injunction. The Quebec Superior Court dealt with this, and this is what they said. No violation of Mr. Amsalem's rights. In order for a practice to be protected under freedom of religion, the practice must be required or be mandatory under the official teachings of the religion. That's important. It cannot simply be a practice that the complaint or the claimant sincerely believes is required. Okay? Now, there was testimony before the court from a rabbi who testified that there was no religious obligation to erect their own sukkahs, and there was no commandment on where it must be erected. And so the court said, okay, well, then it's not covered by freedom of religion. So that was the traditional approach to freedom of religion and, by extension, religious-based creed cases. In the employment context, you probably did this yourself in your own workplace. I know I did, and clients of mine did. When you were faced with a religious accommodation claim, the first thing you would ask is you'd say, okay, thank you very much. Can you please provide us a letter from an official in your religion that first of all indicates that you're a practicing member of that religion, and then second of all says that this particular practice at issue is a requirement of the religion. We all did that. That was the way employers operated. And in fact, I understand that a lot of employers actually follow this type of practice during the pandemic, right? You say you can't take this vaccine, okay, give me something from a religious officiant that says that you're prohibited from taking the vaccine, okay? That was the traditional approach. Supreme Court in Amsalem overturned that approach and instituted a subjective, sincere belief test. So they say religion involves a particular and comprehensive system of faith and worship, fine. It does not simply protect adherence to rules and requirements and dogma of a religion. It also protects sincere, subjectively held beliefs that if you engage in a practice connected with religion, we're going to come to that, if doing so fosters a connection between you and the divine or the object of your faith, then that is also protected. And to be sincere, it's a low test. You only have to have a good faith, demonstrate your belief is in good faith, neither fictitious nor capricious, and not an artifice. And so, okay, so I read that and I said, oh, I had to go consult Mr. Webster, and I think it was Mr. Webster. Capricious means lacking a rational basis, and an artifice is false and tricky behavior. So there you go. That's the test. What did the Supreme Court say in its actual words? This is their actual words. They're saying, this is how the court put it. If an individual claims freedom of religion, they have to say they have a practice or belief that has a nexus, it's a good lawyer word, a nexus with religion which calls for a particular line of conduct. This is a lot of words. But effectively saying that the conduct is subjectively helping my connection with the divine, and I've got to be sincere. Okay, that's the test. Herein lies the conundrum. The Ontario Human Rights Commission released a statement in 21 when we started getting all these vaccines, that said, okay, mandatory vaccination policies are likely to be reasonable if you have protections for human rights and processes. We talked about that earlier. This is important. It also stated that strictly personal preferences are not entitled to protection. And this is their quote. Not aware of any tribunal court decision that found that a singular belief against vaccinations amounted to a creed. While the code prohibits discrimination based on creed, personal preferences do not amount to a creed for the purposes of the code. Okay, so herein lies the question. When is a practice a sincere religious belief entitled to protection, and when is it a personal preference that's not? Also, this is a problem, because we just heard from the Supreme Court that subjective personal beliefs, so long as they're linked to a religion in some manner, and we got some court cases now that suggest that, those are entitled to protection. But aren't they still personal preferences? Particularly if they're not mandated by the religion. So you have to have a tether to the religion, right? You have to have a nexus to the religion. Well, if it's not required by the religion, where's the tether? How does it still remain religious and not personal? These are the questions that these cases raise. So, we have some guidance now. First one, Public Health Sudbury and ONA. This just came out this year. So the Public Health Agency, obviously in Sudbury, they had a COVID-19 vaccination policy as they were required to by the government. Again, they were standard fare, right? You'd be placed on unpaid leave, followed by potential termination. Now here's where the interesting facts arise from a religion perspective. The public health nurse, a griever, was a devout Roman Catholic. That was accepted. But she was a member of a more traditional Orthodox congregation called the Latin Mass. Latin Mass members opposed abortion as a matter of doctrine and belief, but here's key. Left the issue of taking a COVID-19 vaccine to members' personal decisions, right? And the Pope actually encouraged people to have vaccines, right? So, a couple other things. Well, first of all, this was her concern. She believed that the research and the development of the vaccines used cell lines from aborted fetuses, and thus to receive a vaccine would be to condone or cooperate and participate in abortion. Now, the interesting thing is the parties submitted an agreed statement of fact, and the scientific evidence that the parties, i.e. the union and the employer, agreed to, said that fetal cell lines that were only used in the initial stages of research were grown in a lab. They did not contain any fetal tissue. And in fact, they were thousands of generations removed from the aborted fetuses in the 70s and 80s. And they weren't actually used to make the vaccines. So even the arbitrator said, okay, the connection between abortion and these vaccines is remote, okay? So, one more thing. Griever had some inconsistent activities. Her and her family used medicines for years that may have used fetal cell lines. and she administered vaccines in her role as a public health nurse that utilized fetal cell lines. And so the employer marshals all this evidence and essentially takes the position that we have a griever here holding a belief that was not scientific, well, let's say it's not scientifically valid, which is inconsistent with previous actions on her part, but was a personal belief for her to act in a certain way, not take the vaccine, even though there was no requirement in her for religion to act in this fashion, right? Because the religious community said it's up to her personal view. So, is this a personal belief not entitled to protection? Or is this a personal belief that is entitled to protection? What do people think happened, obviously? Entitled to protection. Okay? Basically, the issue was, doesn't matter to the arbitrator's perspective that what the Pope said or what the other members of the church said. For her, it was the fact that there was a community that she was a member of that had a view on on abortion, and that she believed that what she was doing was following that position. That's enough. And they went on and said, since the griever holds a sincere belief with a nexus to creed, so on, that's entitled to protection. Okay, fine. We have that guidance. One more case, and then I'll turn it over to my colleagues again. We have a case out of Nova Scotia that dealt with another public sector employer, hospital, that had a vaccination policy. In this case, the griever was a registered nurse and a Christian of a Protestant congregation, and she submitted a whole bunch of rationales for why she didn't want to take the vaccine. Some were religious, some were not. And the most troubling for her was an objection based on her view that the COVID-19 vaccine was part of a, quote, evil plan, which is the beginning of the way the mark of the beast is being introduced in society. Has anybody ever heard of the mark of the beast concept? Okay, this is a concept that's outlined in the book of Revelations in the Christian Bible. Effectively, the arbitrator summarized the position there, which the beast is Satan. Under Revelations, if you take the mark of the beast on your body, it's a mark, and you can't buy or sell without having that mark. And so this is Satan's plan to get into society. And she took the position that by getting this vaccine in order to work, it's the mark of the beast. But then, interestingly enough, in the rest of her testimony, she said, well, she doesn't actually believe that the vaccine itself was the mark of the beast, but it may well be the platform for the mark of the beast. So it's not even that the vaccine was the mark is the way that Satan is going to enter society, and that's against my Christian beliefs. It's possible that this could be the start of the mark of the beast. That was her position. Other people in the church had a different view of her, protected by freedom of religion. Arbitrator says whether or not that's a reasonable view about the prophetic nature of her views, or whether or not it's shared by members of her church, are questions I simply do not have to answer in order to establish the nexus to religion. She had a subjective belief based on her understanding of her Bible and her religious doctrine. I've got a nexus to religion, and it's sincerely held. So, what does that tell us? It tells us that thus far, arbitrators have taken a very low threshold when it comes to that initial determination of whether a practice or a position on a practice or a position on a policy is connected to creed or religion. Personal beliefs in these decisions that were not mandated or required by religions, including a belief that a vaccine may usher in a satanic practice, not necessarily did, were found to be protected religious beliefs on a prima facie basis. And why am I saying that? Because that's the key. These two cases did not address the whole question of reasonable accommodation. It was just the first instance. Why didn't they? Because I suspect, like you probably have all done in your own cases, okay, listen, arbitrator, we maybe have a deal with the union potentially. Can you just do this and then leave it up to the parties to figure out what to do at the end of the day, right? I just want this ruling. That's all the decisions say. So the arbitrator didn't have to get into the question of, well, okay, if that is a practice and a view, can it be accommodated? Are there overriding health and safety considerations that mean I don't have to accommodate that? None of that's been decided as of yet. That is a TBD item. But I think it's important to take away that not only that's to happen, but how low potentially the threshold is in this first step of the analysis. So it's going to be useful for all of you, not just in COVID cases, but how you handle these cases in the future. So I've said way too much, but we'll move on.
Question. Justin, would you, because of the way the court in Absalom and the arbitrators have interpreted this, would you jump to the second step right off the bat and say, let's assume for the moment, Mr. Arbitrator or Ms. Arbitrator, that this test is satisfied, and let's talk to the reasonable accommodation? Because what is the reasonable accommodation in a workplace where the workers have to show up? There's no social distancing possible. We know that rapid antigen testing isn't sufficient. So do you overleap it? Because the case law is so difficult for employers to meet the test. You might trip up the employees in cross-examination, but if you don't do that.
Well, I have a couple of views on that. Number one, I actually would give that some sincere thought, because I don't like creating bad employer law to begin with. And like, if there's more cases out there that throw more low thresholds in this area, we're all employers here, so we're gonna have to deal with more of those cases. I'd rather just take the position that, okay, let's assume for the sake of the argument there is a violation here, but we're not gonna argue it. Then there's no reasoning on that point.
A prima facie violation, to be clear.
Pardon me?
Prima facie
A
violation.
prima facie violation, yeah. Okay, let's assume for the sake of the argument it is, then there's no ruling on that. It's of no precedential value on that point because it was an agreement. And let's just go straight to the accommodation analysis,
Yeah.
because this law is from an employer. I mean, it matches Absalom. Yes, totally get it. But Absalom, due respect to the Supreme Court, this is probably a career-limiting move, but the chances of me getting to the Supreme Court in my career at this stage are probably slim anyways. And that panel's all changed. I would suggest that this was not an employer or an employment bench that decided this case. This was, it just is unworkable, in my opinion, in an employment context. The old law was, and as a matter of fact, the old law that we talked about was a minority view in Absalom that did not prevail. Maybe it will if it changes. Okay, that's my soapbox, and I'm not going to get on it anymore. I'm done. Shall we talk about paid days? Any questions about that, though? Okay.
All right, so now for the last 10 minutes of our presentation, the most exciting subject, paid sick days. We thought it'd be interesting to talk about paid sick days in the current context in which we are in, with COVID, isolation, vaccination needs, et cetera, et cetera. So we'll give you an overview of paid sick days, but as Hugh mentioned, I will run through the slides that describe every paid sick days possible in all jurisdiction, because that's not necessarily of your interest. We just included it in there because after the presentation, you're going to get a copy of the PowerPoint presentation, and you may want to read that before you go to bed. So, quick overview of the leaves, and then I'll talk about greater right or benefit, what should be provided in your collective agreements, and also best practices. So, first jurisdiction, federal level, there are personal leaves, and there are also COVID-related leave, vaccination leaves provided. There's a major modification to the legislation on the federal level that is anticipated to come into force December 1st. That will now make it the jurisdiction that's the most generous with paid sick leave, bringing it to 10 days, up to 10 days. So I've included here the current provisions. I've also included the new piece of legislation that you can skim through before you go to bed. And I've also included the COVID-related leave and the vaccination leave that is currently provided. And the reason why we wanted to outline those is those statutory paid sick leave are important to consider when you're drafting your collective agreements and when you're assessing whether or not they are already included in your collective agreements. In Ontario, same concept or similar concept, personal illness or injury leave, and IDEL, that's my
Infectious
French,
disease,
that's my French way of saying it. but-
Infectious disease emergency leave.
Thank you. Justin, you may want to quickly skim through that, but essentially, you've got the statutory leaves that are included in there, and you still have the infectious disease emergency leave that is currently in force in Ontario, as I understand.
Until next March
Yeah,
of next year.
yeah, that's where they've extended it. And then you have those in British Columbia, similar concept, in illness, injury leave, COVID-related leave, vaccination leave. You have up to 5 days of paid leave each calendar year, which is also very generous, and you have the COVID-related leaves and the vaccination leaves. Vaccination, 3 hours, you better make it quick, because that's all you're getting paid as an employee. And in Quebec, we have our sickness leave and our COVID-related leave, not necessarily vaccination leave. Quebec was actually, I believe, the only province not to increase its paid sick leave when we had the COVID-19 outbreak. We stuck with our 2 paid sick days and did not necessarily implement anything further. So there's no specific COVID-related leave in Quebec. However, you have the prohibitions that you have as employers, and we don't necessarily have a vaccination leave that is in force, but employees are able to use their sick days if they want to go get vaccinated. So I've included in here a few arbitration awards that are of interest that you can go read afterwards. But essentially, what you want to do as an employer, and I'm really making this quick because we don't have much time left, but the key point that I want you to remember from this portion of the presentation is what do I have to do as an employer to make sure that those paid sick leave are encompassed and included in my CBA from a Quebec perspective anyways, and then you can address the Ontario perspective if you want. And what kind of exercise do I need to do when assessing whether or not they're included, and what kind of language do I need to include in my CBA to make sure that they're included? In Quebec in 2018, there was a new piece of legislation that modified the Labor Standards Act, and that's why it's making it interesting to me, where it introduced those 2 paid sick days. We didn't have that before. It introduced it as of January 1st of 2019, so it's fairly recent, just in time for COVID. There were a few decisions, arbitration decisions, that were rendered with respect to what was the impact of introducing those 2 paid sick days in the statutory legislation in Quebec? Did it give employees 2 additional days of paid sick days, in addition to what the CBAs were already provided in terms of urgent leaves, paid sick leave, or mobile days, or personal leave days? Or was it already encompassed in those days? And the general principle that you need to bear in mind is, does my CBA provide a greater right or a greater benefit? As long as your collective agreements have language that provide a number of days that is equivalent or more generous, conditions to obtain those days or paid leave that are similar to what the statutory legislation is requiring, as long as you're more generous, there should not be a problem. And that's important to remember, because if you have collective agreements that, for example, provide for mobile days or personal days that are conditional upon seniority, for example, or conditional upon a number of hours worked per week, you want to tackle those provisions at your next bargaining session, because if you have those conditions provided in there, you may be at risk of receiving a grievance if you're not giving the statutory paid sick days that are provided. Because most of the time, in Quebec anyways, the statutory paid sick days don't have conditions related to them, but for the 3 months of consecutive seniority that is required. So I had clients, when this piece of legislation came into force, I had clients panicking because their CBAs were providing mobile days, but with conditions to obtain those. Most of them had conditions such as 1 year of seniority. And they were worried that with those conditions, they were going to have to give additional days of paid sick days in addition to what they already had, even though it was generous. But putting those conditions in there was putting at risk the possibility of saying that the CBA was already encompassing the new paid sick days that were introduced in the statutory legislation. So luckily enough, most of the decisions that were rendered in Quebec decided that CBAs providing a number of days that was more generous were encompassing those two paid sick days. And they said the legislator never wanted to give an additional number of days to the employees. And they went back to the basics, and they said the purpose of statutory legislation is really to ensure that employees get a bare minimum. So it's not to give some additional benefits, it's to make sure that at least everyone is getting at minimum 2 paid sick days. And they said the legislator intent was never to give that in addition to the 10 mobile days that you may already have in your CBA. So we were lucky enough with those decisions that I've outlined in this particular slide. But there was a decision rendered in Max Bath, Max AA Bath, where they took into consideration the language and the specific language of the CBA to say, well, the 10 mobile days that you've provided in your CBA, their purpose was really to give employees a number of days for whatever reason they may want. And it's not fair to the employee to use 9 days out of the 10 to do whatever they want. If they want to go shopping one day and they want to take a mobile day to do so, and then at the end of the 10 days, be sick and not be able to get at least 2 paid sick days. So that decision was rendered in 2021. Luckily enough, it's now before the Court of Appeal, so we'll see what the Court of Appeal decides on that. But the norm right now in Quebec is to accept that those paid sick days and those provided days in the CBA encompass the statutory days. But we will see with the decision from the Court of Appeal, the leave to appeal has been granted. So that was a good indication to start with. And then we'll see the decision. It has not yet been rendered. It may change the picture in Quebec, but so far all the arbitrators are going with the same rationale, which is we're encompassing everything. The purpose was to give the bare minimum, and as long as your language is correct and is not providing something for different purposes or with certain conditions, you should be okay. So very quickly, my tip for you guys, if you have provisions in your collective agreements right now about leaves, be it a mobile day, be it a personal day, be it a sick leave or anything of that sort, review your CBAs and ensure that the language that's currently in the CBAs does not provide those conditions. Because if they do, you may want to revisit that to make sure that if we have any further evolution in the legislation throughout all of the jurisdiction, with another pandemic that comes on or with another wave that comes, you want to make sure that you're not stuck giving more paid leave, because that could be very costly for your business, of course. And yeah, so that was my 2 cents. But another thing that I also want to mention is we have a big problem right now in our society with retention of workforce. So on one hand, I'm telling you, review your CBAs and ensure the language is appropriate. But on the other hand, I'm also telling you, be mindful of that problem with retention of workforce, because if it's not necessarily too costly to add one extra day in your CBA, you may want to go with that approach instead of being more restrictive in order to achieve that retention of workforce that we're all trying to achieve at the moment. I don't know if you have anything to add.
It's absolutely true. Absolutely true. I think you've heard it in the media, you've heard it in politician statements, union statements, and the Human Resources Association. I mean, this is an issue. It's an issue at the bargaining table, and so to the extent that you start thinking about this, it's something that I think a lot of employees and by extension employers will almost seeing as the go forward, the necessity of having some degree of paid sick entitlements, but make sure they actually are inclusive of all the minimum standards, because you don't want to end up with more than what you bargained for, literally and figuratively.
Exactly. Okay, does anyone have any questions? Yes.
I just have one. So in our current employment, we had a vaccination policy in place and we've kind of gotten rid of it. We're not enforcing it any longer. Is there a specific trigger that we need to kind of speak to if we want to reenact it? Like, do we say this many number of cases, or like if it goes to a situation where one of the employees doesn't want to follow the policy that we've reenacted? Do we have to then prove that, there's a certain number of cases, or there's legislation that's now put in place?
Does your policy give a trigger?
No.
Then it's up to the management's discretion for which you will demonstrate reasonableness, for which all of those things that you mentioned will come into fact. The things that you've just identified, cases around the uptake, transmissive and new variant, those sorts of things. Am I right, you?
Yeah, exactly.
Claudia?
Yeah, you're going to, just because you had a policy, if you've suspended it or terminated it temporarily, if you reintroduce it, then the union challenges it, you'll have to meet the same test. Is it a reasonable balancing of influence? And on your side would be, of course, the health and safety issues. Yes, Lisa.
I was going to say, the interesting thing about that question is, when you were first rolling it out, public health was pushing you to do it. And I don't know if cases go up, if they will again, because they're sort of, we've
Great
hit
point.
the 80-90% vaccination rate. I don't know if we'll have the support of the public health mandates.
Yeah.
No.
Great point.
Yeah, there were guidelines before, and we don't have those anymore.
Although the arbitrators have been saying, even after government pulled back
Yep.
and withdrew the directives in health, for example, they've been saying, notwithstanding that the employer can still establish a foundation for, continue to establish a foundation, so.
I think public health, they have different opinions depending on where you are. You just received a letter saying mandate your boosters.
Yep.
That was direct.
Yeah, that just came out a week ago or so, didn't it? Yeah.
I hadn't heard that.
Yeah. Yep.
Okay, I hadn't heard that yet.
Yep.
That is interesting.
Interesting.
Thank you. Anybody else? Okay, thanks very much.
Thanks,
Thanks,
everyone.
everyone.